I'm former prosecutor Neil Schaus, and I'm here with former police officer Mike Scafidi. We're both now criminal defense attorneys. And Mike, today I want to talk about this crime of battery on a police officer. And we see this get charged a lot in California in situations where officers go to arrest somebody and perhaps the person is resisting and there's some sort of a scuffle. And they get arrested for this very serious crime of battery on a police officer. First of all, what is it? I mean, what is a sort of legal definition?
Well, simple battery in California is the unwanted, unlawful, and non-justified touching of another. With police officers, you add a protected class. So it's the unnecessary, unjustified, or unwanted touching of a police officer. That could either involve a simple battery or something that causes injury.
So, I mean, it could be hitting the officer, kicking, fighting with the officer. Sometimes we see spitting at the officer charged.
That's correct. And that all could be found under battery on a police officer.
And what are the typical penalties if someone's convicted?
Well, battery on a police officer can be a felony, and it can be a misdemeanor. You can see both. You can be subject to state prison or county jail. County jail up to 1 year, state prison up to 4 years.
And what are the typical defenses? I mean, when you get a case like this, what are typical defense strategies to try to prevent the person from being convicted?
Mistaken identity. A lot of times it's a situation where there's a lot of people milling about, whether it's at a concert scene or a rave or in school, and there's a fight that develops, and the cops go in to break it up, and all of a sudden people are pushing and shoving, and police officers are getting hit either in person or spit on or bottles or whatever, and the person goes into the crowd. They later think they have them, they go in and get them and arrest them, and we find out later on that they got the wrong person. So
it's a chaotic situation, and there's punches being thrown. There's a lot different people doing different things, and maybe the cops sort of single out your client, but it was somebody else in the crowd who actually threw the punch or threw the bottle or whatever it was.
That's right, and especially like the situations we just talked about, you have about the same age persons involved wearing similar type clothes, and so mistaken identity could easily occur in those chaotic situations. Additionally, one of the defenses that we'll use in these types of cases is an accident defense. And people say, what do you mean by that, Mike? Well, for example, if there's a chaotic situation and our client's grabbed from behind, and they don't know a police officer is the person who grabbed them, they turn quickly and their elbow will strike the officer.
Just reflexively turn around or flail their arms.
A momentary reaction in time, bam, and the officer gets hit, chest, maybe in the jaw.
But the client wasn't, certainly wasn't intending to strike an officer.
In fact, wasn't even probably intended to strike anyone. It was a simple accident. It was a moment in time of chaos, close quarters, where there's a touching of the bodies. And the client certainly didn't want to hit an officer.
Now, what about, I mean, we like to think that officers are honest and tell the truth, but a lot of times we know that police officers exaggerate what happened, embellish. Sometimes will outright lie and say, well, the suspect hit me, when in reality that didn't happen. When we get a situation like that where we think the officer is lying and sort of making up a story, what options are there then?
Well, I tell my clients all the time, you're probably not the first person that cop lied about or exaggerated the circumstance, especially if the cop's been on for a while. There is a mechanism in the law called a pitches motion where I, as a lawyer on behalf of a defendant, can request certain records of the officer to see if he's ever been engaged or accused or found liable for in his department and policy of dishonesty, exaggerating facts.
Excessive force,
flat out lying.
Racial profiling.
And these are, once we have that information, it gives us some tools and resources. So it's not just our client's word against an officer's word in court. And we were able to bring other people in, and we have proof that this officer can be a little sketchy.
So basically, our client is charged with striking the officer. Our client says, I never did it, the cop's lying. We go and look at the cop's record and find out 5 other people have made complaints against this cop for excessive force, exaggerating facts, perjury. We can bring those people into court to impeach the officer's credibility and exonerate our client.
We can, and I have to tell you, that's compelling evidence to a jury, because when a police officer gets on the stand and testifies that he's been assaulted by someone in their uniform, that is a strong presence in the courtroom compared to a young 18-year-old or 19-year-old college student who a jury may say, well, they have a reason to lie. Why would an officer lie? But the truth is, sometimes officers lie, sometimes they just get it wrong, and sometimes they exaggerate.
So between these various defenses, mistaken identification, accident, running a pitches motion to sort of get the background of misconduct by the officer, between these various means, we've had a great deal of success in getting these sorts of battery on a police officer charges reduced or dismissed.
We have. We absolutely have. And on the rare occasions where there was a battery, but there are some mitigating circumstances. Our client was in close quarters. Initially didn't know it was a cop. Found out later did, and there was still a little pushing.
Our client has no record, has a job, has a family, has good things going on in his life.
Exactly. May have been drinking, may have not been the person he or she normally is. We get to let the district attorney and the court know, not just that snapshot moment in time of our client's conduct,
but who this person is as a human being.
Their whole life, what they do with their family, their friends, their community, with society in general. And when I was young, my mom said, you're going to have a permanent record. Well, the truth is, we really do. And if you have a good permanent record, we can use that. A skillful attorney here in California will use that to your benefit to mitigate certain actions.
As criminal defense attorneys, there's a lot that we can do for people who are charged with battery on a peace officer.
Absolutely. Just the steps we talked about, and also making sure that the court sees our client as a person and not a criminal defendant.